Hi, my name is Alex Dolphin and welcome back to another episode of Ex Ante. Today we're going to discuss the case of State v. Utter. This case was heard in the Court of Appeals of Washington in the year 1971. Let's go ahead and jump into the facts of the case. So Utter was being prosecuted for second-degree murder. Ultimately, he was convicted of manslaughter at the trial court. What happened which led to this prosecution and conviction was he was in his home and his son came into his home. His son was witnessed to be coming into his home. His son then very shortly after left his home and had been shown to be stabbed. So they didn't have direct evidence that the father stabbed the son, but the son came out, was stabbed and said, "Dad, don't stab me, please." And then he died. So it's very sad that the son died. It seems like the father was very likely to have killed him. The jury convicts. Ultimately, the question here is there's a unique nature about the defendant, Utter, in this case. Utter had served in the military for a number of years. And he had served in World War II, basically was conditioned in this guerrilla warfare type of environment to basically stab people, attack people, right, if they came upon him unexpectedly. So what the attorney for Utter argues is that this was a conditioned response. He didn't really mean to kill his son. It was conditioned because he had been in war for years and had been in the military for years, that he had this response that was conditioned. So the attorney is pushing back and he's arguing there's two components of a criminal act, the actus reus and mens rea, right? So the actus reus is the objective criminal act. And what he's saying is this conditioned response, there was no actual criminal act because it was just a conditioned response. And so the court has to grapple with this a little bit. Normally they would take into account a mental state in mens rea. That's the subjective portion of the criminal analysis. But they do say that there is a minimal level of a subjective nature in a criminal act in actus reus. And the court ultimately grapples with this question of, is a conditioned response, an unconscious, involuntary response, enough to rise to the level of actus reus to charge someone for a homicide? So it's an interesting question. The court grapples with it, and ultimately they say yes, there could be a scenario in which someone's unconscious, conditioned response does not constitute actus reus, and therefore the person is not going to be guilty for homicide. They say in this instance, however, there was not substantial enough evidence to submit that question to the jury. So the jury would be the one to determine, as the finder of fact, did someone, was it truly a conditioned response, or is this just kind of a bluff that they're putting out to try and get out of the crime? So the jury, as the finder of fact, would have to determine that. What the court says is ultimately, if there's not substantial enough evidence, then we're not even going to allow the jury to determine whether there was actus reus, or whether this problem between a conditioned response and a voluntary and willful act. So ultimately, Utter appeals, but nothing goes his way. However, the court does kind of open the door for future defendants, if they have substantial enough evidence, to go ahead and get that question submitted to the jury and potentially get out of the crime if it really wasn't involuntary response. They just said in the case of Utter, he didn't have enough evidence for the court to submit that question to the jury. So it's an interesting question. Is a conditioned response enough to constitute a voluntary act for actus reus? And the court did open the door for this. And some pros to that would be that, this guy, had he have had substantial enough evidence, or let's say future parties, thinking ex ante. Future parties, if they don't really mean to do anything, if it really is truly a conditioned response, and we as a country put this guy out into war for multiple years, it's not really any fault of his own. So it's hard for us to want to punish someone with homicide or manslaughter or murder and lock them up in a cage for many, many years when really they didn't do anything wrong. It was an involuntary response, right? So that would be one of the arguments for him. Another argument for Utter in specific would be like, what does substantial evidence look like? Why can't the jury just look at this question, altogether? Let's let the jury look at it. Let's let the jury decide if there's a substantial enough evidence, right? Because at what point is there going to be substantial evidence? They had introduced a psychiatrist's testimony here in this case. And he certainly had PTSD. He had been in war for many years. He'd been in the military for many years. Very characteristic that, these type of folks would have PTSD. And this was in the 70s. Maybe if we were here in the year 2020, almost 2021, the court would look at this a little bit different and have more sympathy for someone with PTSD, a conditioned response, these types of things. The negatives, and I think the court saw this when they said that there needs to be substantial enough evidence to submit the question to the jury, is, say if we got a really good attorney, and an attorney just really can convince one juror that this was an unconditioned or conditioned an involuntary response, then this person might just get off the hook, right? And if you have a really good attorney that knows this piece of the common law and can say, hey, if we can just argue that that really wasn't a voluntary act, it was just a conditioned response. If we can maybe argue that like you were harassed daycare as a child, or you were doing taekwondo as a little child, and now you just have this involuntary response when someone comes up behind you, then we can argue that you should get off the hook because actus reus isn't satisfied. So there's a very slippery slope, and I think the court tried to counteract that with this substantial evidence kind of factor, that you have to have substantial evidence before it's submitted to the jury. Just kind of hazy. What does substantial evidence look like, right? So just to be critical there. Furthermore, if we have people like this gentleman, Utter, they might not have done anything wrong, but they are still dangerous to society. Folks like Utter who have conditioned responses, they are still dangerous to society. So if the goal of criminal law is to protect society at large, then maybe these people should be, locked up and kept away from society. That's sad to think about, because if it's an involuntary act, then, there's nothing he really could have done within his control to stop this from occurring. But should we punish him and put him in prison, or should we punish all of society and make society fear for everyone's involuntary reactions? And so that's a difficult question to answer and a tightrope to kind of walk. I'd like to just finish up this video with a hypothetical, and to show maybe how slippery of a slope this could be when you do open up the door to saying you're not going to be guilty for involuntary reactions. Let's envision a scenario, and just roll with me, okay? I know everyone doesn't believe in ghosts, okay? But let's say we believe in ghosts, and let's just go back to maybe your favorite horror movie in Halloween, and let's say that a ghost or a demon were to inhabit someone's body, right? And then as that ghost or demon inhabits that person's body, then that person's body then goes and kills someone, something like that. Now, that would be very difficult to prove, but I don't know how much different that would be from this war veteran's reaction, right? You could argue very similarly that this was an unconscious act. The person wasn't conscious of what was going on because really a demon was controlling them at that period of time. And I think the substantial evidence test would get around this, but if there was not substantial evidence and you did submit this to the jury, think about a world where you just convince one juror that this person was, basically possessed by a demon, and it wasn't truly their action that caused the murder, but it was really the action of a demon that caused the murder. If you could just convince one juror of that, you're off the hook. So just that example, I just would like to employ to show that this is a very slippery slope. As soon as you allow people off the hook for involuntary actions, you're going to have all types of people trying to argue that their actions weren't voluntary. And if we get those to a jury, there's likelihood that one juror will break and say that it wasn't a voluntary action, and this person should be off the hook. So that's mostly a video about actus reus, how we balance and that nuance with involuntary reactions, conditioned responses. Do those satisfy the objective, criminal act? So thanks so much for watching. I hope you enjoyed this video. If you'd like to see more, go ahead and hit that subscribe button, and I hope you have a nice rest of your day. Bye-bye.